My Lords, Your Ladyship, one of the issues that this court is being called upon to decide and determine is whether the first petitioner was accorded a fair trial in the impeachment proceedings by the Senate. And this court has had respective arguments and submissions. You will recall Senior Counsel Dr. Thionkulu advancing the argument that the first petitioner was accorded a fair trial by saying the affidavit by the first petitioner in the Senate was adequate, that in fact it is the National Assembly that was deprived of the right to cross-examine the first respondent. And that is the issue I would like to reply to as an issue of law. First, Article 50, Subarticle 1, applies the right to a fair trial to quasi-judicial tribunals and bodies, so that Article 50, Subarticle 1 applied on all force to the Senate when it was conducting the impeachment proceedings. Permit me also to draw this court's attention to Article 25. The people of Kenya, when they gave themselves the 2010 Constitution, considered the right to a fair trial so fundamental that they included the right to a fair trial in Article 25 as one of those rights that cannot be limited. Shows the importance that the people accorded to the right to a fair trial. It is my submission that central to the right to a fair trial is according a party the opportunity to go in the witness box, take the Bible or the Quran, and give oral evidence on oath. It is not enough to say you have filed an affidavit. How many times has this court and other tribunals changed their minds by observing the demeanor, the body language of a witness answering questions in chief, in cross-examination, and in reply? It's a fundamental right. The first petitioner, His Excellency Rigathi Gachagua, wanted to have that opportunity. He would have been led in chief to respond to all the false allegations in the 11 charges that we are facing him. He would have been led in chief. He would have given that evidence. Number two, he would have had the opportunity in cross-examination to demonstrate to the senators, because of his veracity in answering questions, his demeanor, his body language when answering questions in cross-examination would have been an important attribute of that right to a fair trial, including reply in such a fundamental matter as removal from office as Deputy President, having been elected by over 7 million Kenyans. That right to a fair trial, the denial to accord him that opportunity, amounted to a gross violation of his constitutional right to a fair trial. And my Lord, your leadership, this point, this submission that I'm making about the importance of the tribunal, the Senate in this case, having the opportunity to see the veracity, is a witness prevaricating, hesitating in answering questions, or is he confidently answering the questions without hesitation? That opportunity for the first petitioner here to have persuaded the senators, irrespective of the affidavit, that opportunity, this is not the first time that that issue is being raised here before this court as an afterthought. I invite this court, when it retires, to look at the Hansard, which is annexed, the Hansard of the Senate for both 16th and 17th of October, is annexed to the affidavit of Mr. Nyegenye, the clerk to the Senate. The proceeding, the Hansard proceedings for the 16th are in Bundle 1. The Hansard proceedings for the 17th is Bundle 2, both annexed to that affidavit. And when you retire, go through it and you'll see that I drew the importance of oral evidence on oath to the senators. I say at page 12652 of that Hansard record. I said point number 2 is the importance of honorable senators to see with their own eyes how a witness withstands cross-examination. There are many times when different impressions will be given by a written document, and yet when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not when they see his demeanor in person. There is nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes on the mind of the jury. The Deputy President wishes to subject himself to cross-examination and on oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President they believe, or those other witnesses? That opportunity can only come through orality and cross-examination. What this House elects to do, they will make that decision on Tuesday, because the first petitioner was applying for adjournment until the following Tuesday. And I said I'm always an optimist. I'm living in the belief that the doctors will be able to put whatever is wrong with the Deputy President, will be able to put it back in place so that he can be here on Tuesday. If he's not here, let the decision of what this honorable court will then do be made on Tuesday. That is a humane way of going about a matter about which no one had any control. And for the Senate to have deprived that opportunity to the Deputy President, the first petitioner, on the basis of their misreading and misapplying Article 145, and of course not taking into account Article 150, that they had to conclude the impeachment within the two hearing dates, 16th and 17th, at a time when the Deputy President had been taken ill and admitted into hospital. That, in my submission, amounted to a gross violation of his right to a fair hearing by a quasi-judicial body, the Senate, which could not even be limited. And, my Lord, Your Leadership, I was not the only one raising that issue. When you go through that Hansard report, page 12677, you will see the senator for Nandi County, not the county of Nairobi, or the county of Kisumu. He actually agreed with me. You will see what he says on record in the Hansard. As I begin, I want to wish my brother and friend Rigathi Gachagua a quick recovery after that unfortunate incident. The ongoing process has largely gone on well until the adherence of Article 50 came up. And he goes on to say, we have not succeeded in giving a fair hearing to the Deputy President. That is after he had quoted Article 50. The reading of Article 145(4) does not specify the timeline in which the Deputy President's removal can be listened to. It is only by a special committee that it provides for 10 days. So that was very unfortunate in the principle that justice should not only be done, but must be seen to be done. Many Kenyans are asking questions. That is a senator contributing from the floor of the Senate. And let me make this submission. There was never any issue in the Senate on the 17th when I informed the Senate through the Speaker that the Deputy President had been taken sick and was in current hospital. No one raised any issue whatsoever. In fact, if there was time, I would have taken the court through the contributions by members, but permit me to invite the court to look first of all at the Speaker of the Senate, what he said on that 17th. Speaker of the Senate who speaks for himself and for the House. And the Speaker said, honorable senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and wishes for quick recovery to His Excellency Rigathi Gachagua, AGH, Deputy President of the Republic of Kenya. That, I submit, should be accorded weight by this honorable court because it is the Speaker accepting that the Deputy President was sick and wishing him quick recovery. And he was not the only one. As I said, I'm not going to read through, but the minority leader, Senator Madzayo, also sent good wishes for quick recovery. Napeana pole zangu kupitia senior counsel, yours truly, kwa sababu client wako ni mgonjwa. Ugonjwa sio jabu. Ugonjwa ni jambo la Mwenyezi Mungu. Hatuwezi kusema kwamba mtu hawezi kuwa mgonjwa. Mtu yoyote anaweza kuwa mgonjwa. Kwa hivyo ningependa afikishe pole za Senate. Tunamtakia kila heri. Mwenyezi Mungu ampe nafuu ili tupatane tena. And there are many other senators who sent their wishes, so that the summary is this: the issue of the Deputy President having been taken sick, and he had attended the full day the previous day, 16th of July. He had attended the whole morning of 17th. He only fell sick at lunchtime when he was rushed to hospital. But the point I'm making here is that that was never ever in dispute whatsoever. It was accepted, and because the Senate was a quasi-judicial body, they could have sent their own doctor to Karen Hospital to confirm that the Honorable Rigathi Gachagua was indeed unwell and in hospital. And, my Lord, I made that very, very clear. You will see from page 12648, when I addressed the Senate again through the Deputy Speaker. And I said, Mr. Speaker, sir, I would like to inform honorable senators. My Lord, I'm responding on the issue of a fair trial. To deny somebody an adjournment when that person is admitted sick was a gross miscarriage of justice, a violation of his constitutional right. I don't know. I suspect he just wants to interrupt a point that perhaps
no, the point, my lord, is
inflicts damage.
You know, Honorable Muite is a very senior lawyer. We honestly wouldn't want to interrupt his presentation, but he is making his reply as though he is re-arguing and rehashing his case afresh, taking you through, I don't know who said what, which aspects of the evidence. It is not another bite at the cherry. I have really, we have consulted here, and it is with a lot of restraint we are forced to make this objection.
My Lord, that is my pupil master avoiding raising those issues. But when he reads statements, when he reads renditions and contributions from senators, including some in Kiswahili, which he incorrectly reads, it is difficult for us to have an opportunity to respond to some of those factual issues, which are not legal issues. He can respond on principle. We have not got the principle on fair trial, but let him avoid those speeches, especially, and even from Gerald Gay.
I'm not citing anything you said in the Senate deliberately. But, my Lord, your Ladyship, you will remember my good friend here, Senior Counsel, Dr. Bionku, in his submission, he said that the Deputy President was faking illness. He wasn't sick. That is the point I am replying to. It's an issue of law. Was he given a fair trial or not? Obviously, if he was faking sickness, then one can argue that he was not, his rights were not violated. So it's very, very important on that issue. In my submission, the Senate never raised on the 17th of October any question as to whether or not Rigathi Gachagua, His Excellency, was sick and was admitted. That is the point, and it is this answered, it is them. Professor Tom Muite is leading Mokele, Money and Associates. They are the ones who filed this answer. It's part of the record before this honorable court. What harm is there in my strengthening the violation of the constitutional right to a fair trial to a person who is in hospital? And I'm not, permit me just to draw your attention to it. I said I would like to inform honorable senators that I have been able to contact the doctors at current hospital. There is a team of doctors who are looking after the Deputy President because of his condition. I was not able to directly talk to him on the advice of his doctors. They said he must have complete rest for the time being. However, I was informed by his doctors that he is currently suffering intense chest pains, and I did not want to inquire further. I plead with the court that you read through that Hansard all the relevant pages. There are many senators who asked me to pass wishes for speedy recovery. Now, for him to have been deprived of that right of being led in chief, being cross-examined, answering these questions, he would have had the opportunity, for example, to address the false allegations that were made by Senior Counsel Dr. Thiong'Kulu here, that he had grabbed the estate of his brother, ground 8, without any substance. If he had been given that opportunity, he would have been able to demonstrate. And actually he added that the will was forged even before his brother's body had gone cold. Vitriol dressed in eloquence. It doesn't translate into truth. These are issues that Gachagua would have been able to address. His right to a fair trial was grossly violated. And I ask this court to ignore that vitriol. Just like I ask this court to ignore Dr. Thiong'Kulu, my friend, attempting to make a mountain out of a molehill on the basis of the initials RG. Always, this very court does not put the full names of parties to a divorce case in the divorce file. No, they put initials. Why? To respect the constitutional right to privacy. Nothing wrong. And Dr. Gikonyo was here with his file, with the documents. I actually expected my colleagues on the opposite side to ask Gikonyo to table the documents he was being accused of not having annexed. He was never asked to table any of those documents. The second point, before Professor Tom Muite now jumps up again, political doctrine. All I would like to add is that in my submission, the reason for this political doctrine being pushed on this court by the Attorney General through Senior Counsel Professor Githu Muigai and the Senate through Professor Tom Muite. The real reason is that I don't want this court to evaluate the evidence presented by Modusen in court They don't want you to examine the record, Hansel, of the cross-examination of Mutuse, who was the primary witness, cross-examination by senior counsel Elisha Ongoya. Why are they trying to stop this court from doing that? Because they know that if this court does that, the court will come to the inevitable conclusion that there was here no evidence to form the basis of conviction of even a simple traffic offense, leave alone impeachment of the Deputy President. That is why they are telling this court that on the basis of that doctrine, political doctrine, your mandate is to check whether the procedural aspects were complied with by the Senate and by the National Assembly. Procedural aspects. But don't go further to examine the evidence. And Lord, my answer to that is that there are many cases by the High Court, by the Court of Appeal, by the Supreme Court, including the Sonko case and the Wabora case, in which these courts have asserted their jurisdiction. Second point I'd like to make, my Lord, again, the people of Kenya, when they gave themselves the 2010 Constitution, and I invite this court to have a look at Article 1 and Article 2. Article 1 about sovereignty, Article 2 about everybody, every institution, government being bound by the Constitution. The people of Kenya made two important decisions. First of all, it is not by accident that Article 1 was placed as Article 1 and Article 2 about the supremacy of the Constitution was placed as Article 2. It was because of the importance of the Constitution. So the point I'm making, the submission I'm making here, my Lord, is that the people of Kenya made two important decisions. One, they placed their confidence, their total trust in the Constitution. They did not place that total trust in the executive, in the National Assembly, or in the Senate, in the Constitution. That's what they did, Article 1 and Article 2. The second important decision they made was that they, the people of Kenya, by ratifying that Constitution, said in Article 165 that it is the court, they place their confidence in the judges of the High Court to interpret and apply the Constitution and decide whether anything said to be done under any law was done within that law or not. That is a jurisdiction, that is a power that cannot be taken by this court for whatever political considerations there might be. My Lord, the 10 days limitation, even on a plain reading of Article 145, was in Sub-Article 4 limited to the special committee doing the investigations. As far as proceedings in the plenaries are concerned, they would have proceeded on the basis of Article 159, Sub-Article 8, where no time is prescribed. That thing will be done within a reasonable time. And my Lord, even the Speaker of the Senate had at least agreed to adjourn until Saturday. That motion was moved, put to the members, the senators. They voted against even adjourning to Saturday. And they proceeded. A person sick in hospital, they proceeded to impeach him. That was a gross violation. So on the basis of the political question, on the basis of a fair trial, this is a petition that I plead this honorable court should allow. Permit me to say only one word about public participation, and which is this: that given the importance of Article 1, Article 10 and Article 118 on public participation assume greater significance in impeachment proceedings because the sovereignty is vested in the people. And the public participation here was quite simply a sham. My lords, the first petitioner looks up to you to do him justice that was denied him in the Senate impeachment proceedings. That is what the people of Kenya, because it is them who are sovereign, it is them who distributed these jobs. That is what this case is all about. It's beyond being about Gachagua. And finally, on the issue of emoluments, you've been addressing about that. This is not a simple employer-employee case, as was the case with the telecom. This is a petition of an elected official governed by Article 20. Make sure. Article 23 the award of damages. You've got the right to award damages. I think it is Article 160. It's 160. Yes, it's Article 23. E, where the court is given specific jurisdiction to award damages. So I plead that you permit this petition, which will set the president not just for Rigathi Gachagua, but for future impeachments. I thank you.
Thank you. Thank you very much. We have come to the end of the proceedings for today. Now reflecting on what you have been submitting upon since this proceeding started. You've been urging us, telling us that when you retire, now we are retiring. So we will then retire and prepare judgment to bring these proceedings to a close. And we hope to do that on 8th of June 2026 in the ceremonial hall at 11 a.m.